Good morning, everybody, and thank you for joining us. This is the Covenants Restricting Competition Life After the Supreme Court seminar. It's presented by Tina Ranales-Cotos, Stephen Flynn, and myself, Laura Gould. I'm a barrister at King's Chambers, specialising in employment, commercial and sports law. If I can pass over to Tina to give a quick introduction of herself.
Hi, everybody. So Tina Ranales-Cotos, those of you who already know me, I practice at the commercial end of the business and property department, and I specialise in business restraint work, which obviously includes covenants in restrictive trade.
And Steve, please can you introduce yourself?
Good morning, everybody. My name's Steve Flynn, also a member of King's Chambers. My practice crosses between the sports sector and general commercial sector, dealing with restrictive covenant matters in the similar way to Tina does. And that's obviously what we'll be discussing this morning.
Great, thank you very much. Well, we hope that we've put together a useful update for you on recent Supreme Court cases, and then we'll be having a discussion towards the latter third of the hour regarding strategy and tactics for covenants restricting competition. Please feel free to put any questions either in the Q&A function or in the chat box. I'll be keeping an eye on both. We may ask some questions immediately after Tina and Steve's talks, but it may be that we just leave them to the end. But we'll try to get through as many questions as we can in this hour. So we're starting with Tina, and if you'll just bear with me, I will attempt my best to share my screen. And there we go, handing over to you, Tina. Thank you very much.
Thank you very much. So, as per the title, this talk deals with the life after the Supreme Court. So what I'm hoping to do in about 15 minutes max is take us through the last 3 years, which in the Supreme Court has effectively resulted in them producing a relevant case in relation to this area each year. And bearing in mind that prior to that, the last seminal case was probably some 45 years prior. So you might all be familiar with the first of the trilogy, as it were, but it might be worth us starting off by reminding ourselves what the doctrine of restraint of trade precisely means. And so I apologise in advance for those of us that already are fully aware of what the doctrine involves. But it's relevant to note that it relates to all covenants in restraint of trade, and that they are, on the face of it, unenforceable at common law. And they're only enforceable if they're reasonable, and that's by reference to the interests of the parties concerned and the interests of the public. Unless the reasonable part can be severed by the removal of either part or the whole of a covenant in question, then essentially that renders the covenant or the entire contract unenforceable. So that's the doctrine in a nutshell. The difficulty with the doctrine, to some extent, is that it is born out of public policy. And I say the difficulty because, in practical terms, when anything is born out of public policy, then essentially it needs to adjust to social change. And although we're probably going to start with a case in 1414, I'm hoping that we'll end with a case that's probably quite relevant and topical in the context of the COP26 climate summit. But the need to adjust to social change is therefore what drives the policy. So there's a tension between the freedom of contract, where obviously the intention is to uphold whatever the parties agree to, and the freedom of trade, which certainly at the genesis of the doctrine back in 1414, essentially the presumption was that they were all bad and therefore harmful, and therefore any restraint of trade covenants would be void. So the question is always, when advising a client, is this a covenant that falls outside the doctrine, in which case sanctity and freedom of contract prevails, or is it within the doctrine? And of course, if it's within, then it must be reasonable, as I say, reference to the interests of the parties and of the public. And sometimes that last criterion is overlooked. And I think my reference to the topic COP26 case is perhaps one where that public interest comes to the fore. So the doctrine itself is very wide, and we're probably familiar with the doctrine being applied in the context of the classic or the vanilla flavoured contract of employment, and also obviously in the sale of a business. But in the early days of the doctrine, it was questionable as to whether it actually applied to sale of goods, for example. But it's obviously relevant to take care and to note that it can apply in almost any context, but the classic contexts of contract employment and sale of business are ones that obviously one can advise the client quite decisively that they fall within the scope of the doctrine. So the next main slide deals with the formulation or of the doctrine in the House of Lords. So effectively, this was in the context of a commercial agreement. And in that case, Esso Petroleum and Harper's Garage, that involved what's referred to as solus agreement. So essentially an agreement to take all one's petrol requirements for one's garage from one and the same supplier. And one can immediately see how that would essentially amount to restraint of trade. But the question there that vexed their lordships was whether or not what had become a pretty standard contractual obligation was within or outside the doctrine. Basically, in very summary, high-level terms, the majority of the House of Lords, and by the speech of Lord Reid, effectively favoured the pre-existing freedom test as to whether or not the particular restraint fell within or outside the doctrine, and essentially was the individual surrendering a previously or a pre-existing freedom in entering into the contract. And there was a dissenting judgment, and that dissenting voice was Lord Wilberforce's, and he essentially determined that it was a much more pragmatic question, and that in relation to certain covenants, and this was certainly one of them, where there was a prevention of trade or a restriction on trade in the context of land, and also in tied public houses cases, he noted that in those particular instances, there is generally accepted machinery as part of the structure of a trading society, where essentially restriction is accepted as necessary and appropriate to the type of transaction issue. So that became known as the trading society test. And as I say, that was the dissenting judgment. So for 4 or more decades, the prevailing test in the context of those types of cases was the pre-existing freedom test. And in short, that did lead to arbitrary results, because in essence, and perhaps one can see this most visibly in the context of an assignment of a lease, in one instance, the same restrictive covenant could be held to be void and unenforceable because effectively it prevented, it involves somebody surrendering a pre-existing freedom. But on assignment, for example, of the lease with the offending clause, the new party essentially had no pre-existing freedom to surrender, and therefore it would be held to be outside the doctrine. So you have that position where the pre-existing freedom test was heavily criticised for several decades. And indeed, we then start with Tillman and Egan's Ender, where we can see that the tide essentially was retreating in respect of the application of that test. And I think the relevant point to note with the first of the trilogy of these Supreme Court cases is that Lord Wilson features heavily in 2 of the 3 cases. That becomes relevant when we consider the second of the 3 in Peninsular Services. But so far as Tillman and Egan's Ender is concerned, I'm sure many of you will be very familiar with the case. And albeit that this was in the context of the classic employee-employer situation, it is relevant in relation to this issue as to the scope of the doctrine and the relevant text to determine whether one is within or outside the doctrine. That in this case, Lord Wilson essentially didn't have to grapple with the issue, but it's interesting, and effectively, I think it provides the springboard for the Peninsula case. It's interesting to see what he said about the doctrine and the application of that pre-existing freedom test. But I think first, just to put it in context, for those of you that need reminding about the relevant facts, so this was, as I say, the classic scenario of employer and employee post-termination restraints and their enforceability. I think worthy of note here is that the employee was a high-level employee, someone who had shares and essentially was very well remunerated. And in fact, in the first instance decision, the judge referred to the fact that the employer regarded the employee as a bit special. In terms of the restraint in issue, it was a classic non-compete for 6 months. And the relevant part of the clause, and all you need to remember, is that it concerned the meaning of the word interested in. So those of you who practice in this area will be very familiar with that form of restriction whereby an employee is prevented from competing with the ex-employer by way of being concerned or interested in a competing business. Now, a bit of a spoiler here, the employer won in the Supreme Court. But what's interesting in the context of Tillman is the contentions that were being put forward. So each contention raised a different issue with a different hypothesis. So the first hypothesis was that in relation to this non-compete for 6 months and the meaning of interested in, the employer ran the case that actually this interested in part of the covenant was entirely outside the doctrine of restraint of trade. So it wasn't restraining trade to prevent the employee from being interested in a competitor. And surprisingly, perhaps, Lord Wilson, who gave the leading judgment of the Supreme Court, effectively sidestepped the point and said it didn't need to be determined because it was obviously part of the covenant, which in and of itself clearly restrained trade. But in making that observation, he effectively referred back to the Esso case and to the fact that it was a problematic decision that had been heavily criticised over the decades. So we have there some insight into the fact that should this issue come before the House, or rather the Supreme Court again, that there may be a grappling with the issue. But for the purpose of this case, the Supreme Court determined that they didn't need to test the outer limits or the boundaries of the doctrine. It was straightforwardly within it. So the other two issues or hypotheses that the contentions of the employer related to were, the second was whether, if it was within the doctrine, on its proper construction, was it reasonable? And in the context of that particular issue, there were competing meanings, and this is often the case in relation to these types of covenants. And what the court grappled with was when were such competing alternative meanings? At what point could the court effectively abandon one meaning in favour of another? And the validity principle was an issue. And in short, what the court determined was, if there was an alternative competitive meaning or competing meaning, then insofar as the validity principle was triggered, then there was a need to determine, was the alternative meaning a reasonable one? And in essence, and I suppose a salutary lesson is that if you're going to say that your clause is enforceable, then you have to put up an alternative meaning, a realistic alternative meaning. So on the facts of that case, rather bizarrely, the employer did not grapple with that issue. And I think the main difficulty there, however, is that the word interested in, according to its natural and ordinary meaning, essentially meant a passive interest in a company, which of course includes shareholdings. And finally, the third issue with the hypothesis third issue is that even if it was within the doctrine, it could be severed. The words interested in could be severed. And this is where essentially the meat of the decision can be found. And in short, what the court did was effectively overrule the Court of Appeal's decision in Atwood and Lamont in relation to the principles of severance and when the doctrine applies. And all you need to know is that so far as Atwood is concerned, it is overruled. That's no longer the test for severance. But interestingly, yet again, we see how public policy, which the court made clear, was effectively the basis for severance, was in need. The approach to severance, the more restrictive approach that we can see that was seen in Atwood and Lamont, was in need of updating essentially. So the Atwood test, which as I say is overruled, is that you can only sever where you're dealing with a single, you're not really dealing with a single covenant, and where what you're attempting to sever is trivial or technical. And if the part to be severed was partly unreasonable, then that would make the whole of the covenant reasonable. And that test had itself commanded criticism over the years. So as I say, it was overruled by Lord Wilson and replaced with a threefold test. And in short, that test is, and the clue is in the word severance, it can only be severed if it would not result in an addition or a modification. So in other words, the blue pencil test, if you can rub it out, i.e. cut it out, then that would satisfy the test. If you have to actually add or modify the words, then it wouldn't satisfy the test. The second limb of the threefold test is whether or not, once excised, what remains, there is adequate consideration to support it. To some extent, that was a product of the cases that led up to the Tillman case, and by and large, it can be ignored where you're dealing with severance in the context of the employer attempting to sever. So far as the third limb of the test, what one has to then consider is whether or not the severance would result in no major change to the overall legal effect of the restraint. And it's important to note that it's the legal effect. So it's not to be viewed from the perspective of whether what remains signifies a major change so far as the employer or employee is concerned. It's the legal effect of the covenant. So that's the first of the trilogy of the Supreme Court cases. But the important point to note there, leading into the second case, Peninsula, is what Lord Wilson had observed in passing in relation to the doctrine and its boundaries. So then we move on to Peninsula. So a year later, August 2020, the Supreme Court, again, Lord Wilson. And perhaps interestingly, this was his last case before he retired. So whether he decided to be brave or whether, in fact, it was simply time to sweep away the old test, who knows, but interesting to note. So, but in the Peninsula case, where it firmly in the realms of commercial parties, and in the scenario of a shopping centre, owner of a shopping centre leasing part to a retailer lessee who was to become an anchor tenant, so an important retailer in the context of the shopping centre development. And here we had a covenant not to permit building of a major store in competition with the anchor tenant. So plainly on the face of it, in restraint of trade. And the question there was whether or not the doctrine was engaged. And in short, Lord Wilson effectively went back to the Esso Petroleum case, and in an interesting tour of the Commonwealth, essentially considered whether it was now time to do away with the pre-existing freedom test, which had been the subject of significant criticism both in academia and in the jurisprudence of particularly Australia and Canada. And ultimately, he decided that the time to abolish the pre-existing freedom test had arrived. And essentially he favoured the trading society test. So that was the, as you might recall, the dissenting judgment in the SO case, which had been born out of a pragmatic approach and in considering whether something had become generally accepted machinery as part of the structure of a trading society, whether it was necessary and acceptable. Now, in relation to that aspect, you might be forgiven for thinking, therefore, that essentially is the sole test when considering in the context, say, of a commercial agreement as to whether or not the doctrine applies. But in Peninsula, one can well see how that could be easily applied. And indeed, Lord Wilson, in applying the test, said it's now straightforward to determine whether or not this restriction is within or outside the doctrine, and applying the trading society test in the context of shopping centres and anchor tenants. It had long been part of the machinery of that type of transaction to have such a restrictive covenant or a restraint of trade of that nature. So far, so good. If you're advising in those classic situations, employer-employee, or in the context of vendors of business, or indeed in this scenario in Peninsula, in the context of restrictions in relation to land, then one can easily see how that test is engaged and how it can be applied. However, of real interest, it seems to me, and if there's only one thing that you take from this talk, I'd actually, and if you're in the realms of advising commercial clients and you're not within those well-oiled parts of the trading society where you have essentially a well-trodden, well-versed type of clause, then you would be well advised to consider Quantum Actuarial LLP and Quantum Advisory Limited, which is actually a Court of Appeal authority. But that authority essentially applies the Peninsula test, or seeks to apply it. And it's an interesting case and is very helpful in my submission in relation to advising clients when you're essentially dealing with a bespoke agreement. The context of Quantum, and all you really need to understand about it, is that it did involve exactly that, a bespoke services agreement by commercial parties. And this was a complicated corporate restructuring arrangement. And the key to understanding the case, perhaps, is that context, because essentially it was a service agreement that involved an entirely new entity, the LLP, who prior to the agreement didn't really exist and certainly hadn't traded. And the background and the facts are quite complicated in themselves, but in essence, it involved the provision of pension services. And in short, the restructuring involved the new LLP essentially servicing the clients of the old companies known as legacy clients. And in that context, the service agreement itself contained a non-solicitation of clients clause. And interestingly, that clause applied for the duration of the contract, which was 99 years plus 1 year post-termination. So it's interesting to note that the issue that arose in terms of whether or not the doctrine of restraint of trade applied arose in the context of a restraint within the contract rather than post-contract. So in the first instance judgment, which actually was handed down pre-Peninsula, I think it was in May 2020, and Peninsula was decided in the August. The judge effectively found that this agreement and the restraint was not within the doctrine, and if he got that wrong, it was within the doctrine, then it was reasonable. Now, ultimately, in the Court of Appeal, that decision was upheld, but for slightly different reasons. And interestingly, it was the Court of Appeal obviously was in the position to apply the Peninsula Trading Society test. And the Court of Appeal grappled with that. And obviously, endorsed the fact that the pre-existing freedom test had certainly been abolished. But so far as the trading society test, what the Court of Appeal found was, applying all the principles from the authorities, including the Peninsula cases, that the trading society test was not a one-size-fits-all. And so, although it can be relevant in certain contexts, in the context of a bespoke services agreement such as this, it was not the relevant test. And it seems that from that, what we actually have, and it's paragraph 60 of the Court of Appeal decision, the Court of Appeal very helpfully drew together all the relevant legal principles. So helpfully or unhelpfully, in short, what the Court of Appeal determined is that the doctrine is not itself confined to boundaries or rigid categorizations. There are certain categories that traditionally the doctrine applies, and of course those are the classics of employer-employee and also sale of the business. But also it has been held to apply in other contexts, as we know, franchise agreements, share purchase agreements, and the like. So in essence, there are no clear limits to the doctrine and the scope, and no precise or exhaustive test can be stated. So it's basically to be applied to different factual situations in a broad and flexible rule of reason way. So effectively, contractual restraining provisions, which are of a sort which have become part of the accepted machinery of a type of transaction, which have generally been found acceptable and necessary, reflecting the accepted and normal currency of commercial or contractual conveyancing relations, will generally fall outside the scope. So that's essentially the trading society test. So that's a given, if you like, now. So we have these categories that are either the classics or they're a given. But determining whether contractual restraints fall outside the range of a normal commercial contract imposing restrictions on a contracting party's ability to carry on a business activity is a question of evaluating, here we go, all the relevant factors to be assessed cumulatively. And it's to be carried out by reference to the position as at the time that the contract is made, not by reference to subsequent performance. How the contract turns out may be relevant only insofar as it furnishes evidence of the nature of the contract in question when made. And then the application depends less on legal niceties or theoretical possibilities than on the practical effect of the restraint in hampering the freedom of trade. So it's a question of substance, not form. The doctrine can apply to restraints operating during the currency of the contract, as well as post-contractually, which of course is what the Court of Appeal was dealing with in Quantum. But it's not without its relevance, whether it's pre or post-termination restraints that you're looking at. So the fact that the restraint is limited to the period of the contract might actually be a factor in its favour, and excluding in relation to excluding the doctrine. And then where the doctrine does apply, obviously then whether or not those restraints are prima facie unenforceable, and then they are subjected to the test of reasonableness. And obviously that includes, in relation to the Tillman principles, whether or not the offending part can be severed. So in short, the response of the Court of Appeal in applying the Peninsula test is that it's a flexible rule of reason test as opposed to simply the trading society test, and no two cases are the same. The Court of Appeal also provided an interesting roundup of what reasonableness means, and that's at paragraph 62 onwards of their judgment. We're probably all familiar with it, but reinforces the fact that the onus of establishing whether the covenant is no more than reasonable in the interest of the party is on the party who seeks to rely on it. Once that party does establish that it's no more than reasonable in the interest of the parties, the onus of proving that it's contrary to the public interest lies on the other party. The time for considering reasonableness is the time that the parties entered into the contract. For a restraint to be reasonable between the parties, it must be no more than what was reasonably required by the party in whose favour it was imposed to protect his or her legitimate interest. And the court can consider whether a narrower covenant would have sufficed to protect that interest. And what is reasonable may alter with the changing nature of commerce and society. And then the Court of Appeal set out various factors that might be considered in relation to reasonableness, including the relevance of the consideration for the restraint, inequality of the bargaining power, standard forms of contract, whether it operates during or post the contract, and the surrounding circumstances. And obviously the duration of the restraint is probably one of the most important issues in determining whether the restraint can be justified. So that really brings us to the third case, which is the Harker-Sinclair case. And it may or may not be of interest to those in the audience that the Harker-Sinclair case, context of that case was a solicitor's undertaking in a non-disclosure agreement. Now, in essence, that provided for a 6-year non-compete in the context of effectively soliciting claimants in a group litigation scenario. And the group litigation involved the emissions litigation, which some of you will be familiar with in the context of Volkswagen. But what was interesting here is, and perhaps unsurprisingly, there was no real argument as to whether that sort of and it was a 6-year non-compete covenant fell in the doctrine. So whether you're applying the trading society test, or in the context of this NDA, the relevant principles summarised by the Court of Appeal in Quantum, it was plain that this would come within the doctrine. But what's interesting about the Harker-Sinclair case is how it is that the court came to uphold the actual restraint, bearing in mind that the restraint had been set out in a contractual document, a non-disclosure agreement. But what's interesting about this case is that when one is considering what's reasonable in the context of the legitimate interest of the party, is it no more than reasonably necessary? The court did not consider that the parties were confined to the actual terms of the contract, because actually in the context of that case, the non-disclosure agreement was actually entered into with a view to the parties entering into a subsequent agreement for collaboration. However, that wasn't effectively set out in the non-disclosure agreement. So the relevance of the Harker-Sinclair case is when one is determining, is it reasonable? And those of you who practice perhaps exclusively in the employment context will be familiar with the fact that often the legitimate interests of the employer are set out in the contract of employment. And that is the benchmark, if you like, against which the reasonableness of the covenants are tested. Here, what the court determined was that the court can look outside the contract to determine what the objective intention of the parties or what was in their contemplation about what would occur post-contract as a consequence of entering into it. And of course, there on the fact, what the parties intended, their objective intention, I should add, not obviously subjective, was that they would effectively enter into a collaboration agreement whereby essentially the defendant would collaborate with the claimant, use the claimant's resources, etc., in order to bring the group litigation to life and to pursue these emission claims. And although that wasn't actually set out in the contract, the court, looking outside the contract to those objective intentions, was then prepared to uphold the 6-year non-compete on the basis that it was no more than reasonable to protect those legitimate interests. And equally so, when looking at the commensurate benefits to the other contracting party, the court is not restricted to looking at simply the terms of the contract, and again can look at, provided it's the objective intention or what was in their contemplation, as to what would occur as a consequence of entering into the contract. So that's an interesting enlargement, one might say, in relation to when one looks at what's reasonable and the legitimate interests, whether one can go outside the four corners of the contract. So I think my time is up, but I did say that I would try and bring it full circle to perhaps a more topical scenario where public interest and public policy can be seen to be in play And for those of you who are interested, because of the time constraints, I'll just refer to the case. It's Biosol Renewables and Lovering and others. But in short there, the court found that in relation to the reasonableness of a restraint, that so far as the public interest is concerned, restraint fall foul on that basis because of its environmental impact. So that's essentially an interesting case in the context of public interest, which rarely features in these types of cases. So I think having overrun my time, I'll hand over now to Stephen.
Thank you, Tina. My part of the session this morning is going to be a whistle-stop tour through some of the issues arising. And I should say at the start, I apologise that I have a cold, so I'm more nasal than normal and hopefully not too monotonous in my speech, but nothing I can do about it. If I can go to the first slide, please. Thank you. This is arising from the Tillman case that Tina was speaking about. And it's a issue in relation to drafting, and it's not a legal development, more of a warning one could use for clients as to why they should use lawyers to draft bespoke restrictions. So in Ms. Tillman's case, the restriction related to, as Tina referred to, her being interested in any business. And the argument was that being interested prohibited Ms. Tillman from having even a minority shareholding in her company. Now, her contract of employment, which is the next slide, please, at clause 4.5, expressly allowed her to hold 5% of the total equity shareholding in a company, as long as that was for investment purposes only. So we had the situation where during her employment, Ms. Tillman was expressly permitted to hold 5%, but post and termination, she wasn't going to be able to under the terms of the restriction. Now, it appears, it's not expressly said in the judgment, that whoever inserted the restriction didn't notice the inconsistency between those two terms. The consequence of that was that the company, when they came to court, could not reasonably argue that it had a legitimate interest in having a wider restriction post-termination than it did during the course of her employment. So it took away an important argument that could have been used by the company. So I use this as just a salutary warning for everybody, because we'll all be familiar with clients who get lawyers to draft the restrictions first of all, and then suddenly use that wording and insert it to all the contracts, and don't consult the lawyers as to actually how it interacts with the other terms. Now, that's a very risky strategy, I'm sure we'd all recognise, and this can be used as an example of that. Any restriction should be bespoke, taking into account that the role that the individual is going to perform. And if that isn't the case, then it can make matters very difficult when it comes to enforcement. Also, from a lawyer's perspective, picking up on something Tina said, it's important to review all of the documents to put the restriction in context when you're drafting any restriction, and how what you are drafting can interact with other documents. So I'm thinking in terms of, in an employment context, you'd also want to see the staff handbook, because that may be contractual. If you're dealing with people who are in the financial services sector, you'd want to be familiar with the regulations. Similarly, in support sector where I operate, the regulations that would apply in those circumstances, or in a sale and purchase agreement, whether there are any side letters or matters or side agreements that may interact with the restriction, so as to put it in context. So I think that's the first practical matter that I would say has arisen. The second point arises from the final paragraph of Lord Wilson's judgment in Tillman. If we can have the next, it's open, yes. So this was, Tillman was the first case to go to the Supreme Court or House of Lords in 100 years. So there's lots of discussion about the matters that Tina has already discussed this morning, but I think the final paragraph got overlooked in the media discussion. And I think that's unfortunate, because it is an important point on a practical basis. Lord Wilson said, as you can see there, that in his view, the company should win on the basis that the offending wording could be severed, but there might be a sting in the tail. So that cryptic message from Lord Wilson was actually a reference to a previous case called Fresh Asia Foods. In that case, a Deputy High Court judge commented that overboard and uncertain restrictions are legal litter, as you can see there. They place an unfair burden on others to clean up, and that even if there's a kernel of justification in the claims, that should not be without consequence. What they were saying is that even a successful claimant, somebody trying to enforce a restriction, may face an adverse costs award. The rationale for that is that in severance cases, they arise from the wrongful action of a claimant attempting to subject a defendant to a clause that is ultimately partially invalid. And that is what they were describing as the legal litter. And if you have put something in your restriction that is legal litter, you should be responsible for the costs. Now, that is a very significant case on a day-to-day basis, because we'll all be familiar with the claimant sending a pre-action letter seeking to rely upon a restriction. Almost inevitably, the respondent will reply saying it's a restraint of trade, it's unenforceable, we'll avoid this if it goes to court. In light of Tillman, claimants now invariably go, hold it up, here's my winning lottery ticket, I can rely upon Tillman to say anything that's unenforceable can be severed. The answer to that, if we look at the final paragraph of Tillman, is to say, well, if that's the case and you want to run this to court, you're going to be liable for the costs. That is the sting in the tail. So I think it's a very useful, on a practical day-to-day basis, paragraph to refer to in a hope of moving parties towards settlement, because claimants are going to be very reluctant to pursue cases to the courts if they're going to end up having to pay the costs in any event. It's also important warning for claimants if you're advising them. If you're going to advise a claimant that, yes, we think we can win, if the offending part of the restriction can be severed, you'd want to take a very detailed note that you warn them that they might be on the hook for the costs, because often otherwise they could have a very unhappy client at the end of the the proceedings. The next point I'm going to make is very brief in relation to express severance clauses. You will all have seen contracts that refer to a clause that says in the event that part of the restriction is found to be unenforceable, then it can be severed, and that is inserted into the contract. The important thing is to know that that has little impact. All that it does is reinforce the court's common law power, which is exactly what Tillman was looking at. They don't add anything to the contract. And so insert them, don't insert them, but don't think that they add anything to what the general underlying principle is. And the UK Power Reserve case is a reference to that. The final point I'm going to refer to is in relation to the practicalities of preparing witness statements for these type of claims. When we have clients come in and ask us about, is this restriction going to be enforceable? The thing they hope most is, it depends. But looking at Harker, Sinclair, and as Tina referred to, you will be looking at not just the contractual wording, but also the surrounding circumstances. So often the wording, the response will have to be, it depends on the context. We need to know the context. So what we really need to know, and I think this is for any case in restrictive governance, but particularly when we're looking at severance cases, is understanding the nature of the client's business, how it operates, who its competitors are, what are the unique elements that this client offers, and what are its essential IP that it's seeking to protect, and why it considered it necessary to restrict its interests in the way that it did. That information needs to be put before the court. The court needs to understand the business, not just what the contract says. The court needs to have a full flavour of what's going on if it's going to deal or find in your favour. But also if you're resisting an interim application, an injunction application, or at trial on behalf of the defendant, to undermine what is being said by the claimant as to how the business operates, because the person who is the defendant will have a unique insight into how the actual business works and may be able to shed a different light on matters for the court. If that information isn't presented, then the court may well find that there is an legitimate interest to protect, and that can be fatal to the claim. Now, that point was made very clear in a judgment in the Quilter private client and Falconer case, which is referred to on your screen. That is an interesting read in the sense of how not to prepare witness statements for these types of cases. In that case, the judge was very critical of the claimant for putting in a 166-page statement, which were described as impermissibly regurgitating large parts of the pleaded case, reciting large amounts of correspondence with a running commentary on those exchanges, and over 100 pages discussing the disclosure that was delivered after the delivery up order. The judge was absolutely hammered the statement and was very unimpressed by it. The judge also made reference to the fact that it contained phrases such as the non-compete restriction was necessary because it was difficult to police post-termination confidentiality otherwise, and that the restriction was an industry standard when seeking to justify the non-competition clauses. The judge said that those phrases carried little weight and added very little to the court's understanding of the restriction. So what I say is there needs to be a focus on what the court needs to understand about the business. So in relation, for example, to confidential information, what is the information? Why is it confidential? What steps were taken to protect it? What is its shelf life? In competition, who are the competitors? Where do they operate geographically? How big is the market? How much churn is there between clients and between different companies? Those are the kind of matters that need to be aware. And in relation to that phrase, industry standard, we've all seen it. It comes up regularly when clients come to see us. But you need to adduce evidence of exactly what that is. And how you've come to understand that that is the industry standard. Unfortunately, in my experience, what often happens is the client says, well, I took the precedent from my former employer and I've put it just a different heading on, which is not a great answer and may give rise to other proceedings from former employers. But it does just illustrate the point in the Quilter case that there needs to be evidence-based assertions in that regard, because in the Quilter case, there wasn't the evidence of the industry standard, and actually the defendant managed to undermine the fact that that was the case. Let's say there's a whistle-stop tour through what I see as some of the most significant developments arising from the Supreme Court cases, and hopefully they're of some assistance to you.
That's great. Thanks very much, Steve and Tina. Right, we're going to have a quick Q&A on tactics and strategy between the three of us that we hope you'll find useful. And if you've got any questions arising, please do put them in the Q&A or chat function. And hopefully you'll be able to see us more clearly for this part of the discussion. So looking at what we've been asked so far, we have a question from Matthew. Where an employee has been in situ for, say, 25 years on an old contract with no very limited or poorly drafted restrictions and has no prospect of being promoted or given any additional benefits to aid the incorporation of more restrictive clauses, to what extent does the common law and equity come to the aid of the employer? Can any further restrictions be imposed that would be enforceable without the further consideration passing from the employer to the employee? So I think what we're really saying is, if there's no consideration, is there anything we can do about it? Tina, what do you think?
No. More importantly, I just wonder, maybe this is entirely hypothetical, there's a real contradiction there, because on the one hand, it appears that this employee, long-standing, is not in any way valuable to the employer, such that there's no prospect of a pay rise or a promotion, but on the other, the employer somehow wants to seek to restrict the employee's activities. So it's a fundamental basis for restrictive covenants that needs to be adequate consideration. So I think you've got to review. I'd turn it on its head. I'd say, why is it that the employer wants to impose further or additional restrictions? And that will probably unravel the entire thing. And it may turn out that then will lead to discussion as to how that can be done. In short, it's a variation of a contract. And obviously, in the context of employer-employees, it's one where you really do need to make sure that there is adequate consideration.
Well, I think that seems to hit the nail on the head, unless you've got anything you want to add, Steve.
No, that's exactly the point, I think.
Great. Okay, so we have another question, which is about advocacy and the way we put across a case. Is it possible for the parties to affect how the court approaches the interpretation of a restrictive covenant, i.e. to adopt a purposive approach, so that save any offence caused to wider public interest, laws might be saved where perhaps in the question asking about the wider surrounding circumstances there. So just looking at that second question in the Q&A, Steve, have you got any comments on that?
Well, I suppose it very much to your initial point there, Laura. It's an advocacy point as to how you advance your case. And I think very much to the way Tina went through those authorities, we're going very much towards a purposive approach of understanding the commercial nature of these restrictions rather than looking at the black letter of the contract. So I think that's the way judges approach these things these days. And I don't think it would need much nudging in that direction from the advocate. In terms of how the parties could affect it, I don't know what the question asker had in mind, but I certainly think, as I say, that's the way just things are going these days.
Okay, well, just checking you can still hear me. I think my AirPods have died after an hour, unfortunately. But moving on to some more general questions, what would you say the top tips are for responding to pre-action correspondence to try and stop hearing? It's all well and good when you want to make sure you've got reasonable clients on each side, but if you haven't got that, how can you try and take the heat out of the situation and resolve matters early?
So in my experience, it's the antithesis of the kitchen sink approach. Really, it's to focus on your best point. And just to try and add a bit of levity, and I hope it's not too early to mention the word turd, but I did marshal for the wonderful Mr. Justice Laddie, who's no longer with us, several decades ago now, I have to confess. But he actually said to me that if you've got a good point, make it. Don't dilute it with a bad point. And it's turd and the cake principle, which is, if I were to offer you a delicious slice of lemon drizzle, but on the side of that plate there was a turd, then it would probably deter you from accepting the cake. And it's the simple point that the kitchen sink approach is one that I find often when I'm asked to step in, say pre-action correspondence, you pour through it and you think, my goodness, we've got an amazing point in here, but it's lost with everything else. So focus on the best point, the good point, because that's the point that's going to win the day. Because months and months of pre-action correspondence, if it leads to either interim relief or trial, then essentially it often turns on one point and it's your best point. And I suppose that leads nicely into this thing in the tail point as well, in relation to the actual drafting of the covenants and trying to ensure that they are no more than reasonably necessary. But if you're having to deal with a covenant that has modified sort of versions and alternatives, then focus on your best point.
I think that's a really good point. And I think when you get that kitchen sink approach, it often comes with that higher level of aggression in the correspondence, doesn't it? Which we all know. And I suspect many of the observers on this seminar this morning, we see it from both sides. And we know that actually it doesn't have necessarily the force that we want it to. And I think if you've got the kitchen sink along with an aggressive approach, it probably prevents you from ever trying to get matters resolved at that early stage, because it just doesn't look reasonable. Steve, have you got any tips you could add to that?
Well, one is a personal crusade of mine in relation to the question about avoiding matters going to court, is to consider the alternatives in terms of arbitration, because matters, courts are willing to accommodate speedy trials these days, certainly more than they used to be. But arbitration does provide an alternative in terms of quick resolution of matters, confidential resolution of matters. And if you are in a developing sector, as in terms of Tina was talking about, or a financial services sector, you can appoint arbitrators who've got intimate knowledge of that sector and can bring that to assist. So I do think, in terms of taking the question from a very literal point, a way of avoiding court that should be considered is the use of arbitration in these type of disputes.
Well, if that can't be avoided, Steve, for whatever reason, if someone hasn't managed to be persuaded by you, and we're going to court, you're issuing an application, urgent application for an injunction, what are the main mistakes that you've seen that can prevent an injunction from being granted? Or really what I'm asking is, how best do you get your ducks in a row before you go to court?
I think it's the point I was making earlier about witness statements, that the clients have a natural inclination to just want to tell everything and complain about everything, whereas, very much on Tina's point, you want to focus on what does the court need to understand, what is it about the industry, the business and the individual that the court needs to fully appreciate, and to have that kind of focus about it. And also to have the person who's dealing with it and giving the evidence, somebody who's involved on a day-to-day basis. Often we have conferences where people bring in very senior executives from a company and in-house lawyers, but they're no use to me, without being too flippant. I need to know the person who knows how it works and is able to explain why this person doing this thing is causing damage. So I think that would be a key duck to put in a row, that when you're coming to counsel, you bring the person who knows the business with you, and we can get to the bottom of what actually happens.
Tina, what would you find particularly helpful to best present the application when you get to court?
I think it's really to echo Stephen's point. I mean, obviously, the point that Stephen makes about witness statements, and particularly the reference in the case to the 160-page length statement, obviously, and I know it obviously only applies in relation to trial statements, but we have the new practice direction, which should mean that the days of 160-page statements that effectively adduce documentary evidence and tell the judge what the law is, and dare I say, even make submissions, are gone. But key to an interim application is a pithy witness statement from the relevant person dealing with the facts. I mean, as Stephen mentioned, I mean, ultimately what the judge needs to get to grips with very quickly are the factual basis for the application. And that then requires the witness statement to speak to the context, the business, the legitimate interests, and ultimately, you know, if it's an interim application, why damages are not an adequate remedy, and obviously the cross-undertaking damages. You know, those are the things that need to be in the witness statement from the key employee. And as Stephen said, it's really important to identify who that is at a very early stage. So obviously the other point, which I don't think I need to make, is make sure you have the right counsel.
Excellent, and that's advocacy for you. Just before we sign off, I'll try and pick up on some more points in the Q&A. I think what the question is really wanting to know is, how do you best convince the court to apply the blue pencil to the contract? If you've got an issue and you say it needs to be severed, how best do you convince the court to do that? Or is it just a case of it'll be obvious, if you can, you can, if you can't, you can't? What do you think, Tina?
Yeah, sorry, I was just looking at that question. I'm not entirely clear whether that is what the question is asking, but in terms of context, I'm not entirely clear. Obviously, the context in which the clause is being applied needs to be firmly and squarely set out in the statement. In terms of the blue pencil test, I mean, all one needs to do is waive Tillman, really, and essentially refer to the fact that you're not adding, you're not modifying. And it's now become part of the test. I mean, it's no longer the case, and obviously Stephen's talk underlines this in terms of the sting in the tail, but it's no longer the case that the test is, you know, is it within, is it outside? If it's within, is it reasonable in relation to the interests of the parties and the public interest? there is a further, if you like, additional requirement. Can it be severed? It's now, fully grafted onto the doctrine. So it's not a question of should the court apply, can it apply severance? Severance is part of the question. Whether it will sever depends on the quality of the advocacy and whether or not you're adding or modifying, which means you can't sever, and ultimately whether it would result in no significant change to the legal effect. So it should be part of the question. And every case involving restricted covenant, I mean, if you get a restricted covenant case, you should be asking whether it's if there is an offending part, if there's a part that troubles you, can that be severed as per the Tillman test? And if it can, then it's enforceable. And that goes to the pre-action point, which is, put forward your best point. If if you're concerned that unless it's severed, it won't be upheld as reasonable. It's not about making that concession. It can be worded in a way that doesn't actually concede the point. But then you hammer home the severance point, and that it's obvious that it would be severed, and no judge would even question whether it could be severed. It's about the approach, isn't it?
Yeah. Absolutely. Well, that has us running out of time, I'm afraid. So sorry we didn't manage to get through more questions, but we hope that you've all found that a really useful talk. So thanks to Tina and Steve for the effort in reviewing those cases. I believe that the slides are going to be sent out. If anyone has any follow-up questions or inquiries, just get in touch through the marketing email that you will have booked this through. Thank you very much for joining us all this morning. Have a great day.
Thank you.
Bye now.